If you think the Supreme Court's ruling on transgender sports today is a simple 6-3 split where conservatives win and liberals lose, the legal reality is more complicated than that. And the details embedded in this decision, including one aspect that is genuinely unanimous across all 9 justices, have consequences that reach far beyond school sports and well beyond the 2 states directly involved. June 30th, 2026, the Supreme Court issued its ruling in West Virginia versus BPJ and its companion case, Little versus Hecox. This is the final ruling of a historic term that has also produced decisions on birthright citizenship, campaign finance, presidential removal power, geofence warrants, and immigration protections. And this one is, in some ways, the most legally complex of all. Subscribe right now because I am going to walk you through exactly what the court held, what it did not hold, who actually agreed with whom, and what remains legally unsettled. Let me start with the 2 young people at the center of these cases because understanding their situations is essential for understanding what the court decided and why it matters. Becky Pepper Jackson, known as BPJ in court documents, is a transgender girl who lives in West Virginia. She began socially transitioning in 3rd grade. She received puberty-blocking medication to prevent the physical changes associated with male puberty, and then began hormone therapy in 6th grade. She wanted to compete on her middle school's girls' cross-country and track and field teams. West Virginia's Save Women's Sports Act, passed in 2021, prohibited her from doing so. The law restricts female sports teams to students assigned female at birth based on what the law calls reproductive biology and genetics at birth. BPJ and her mother sued, arguing the law violated the federal civil rights statute known as Title IX and the Equal Protection Clause of the 14th Amendment. The federal district court originally upheld the law. The 4th Circuit Court of Appeals reversed, finding the law discriminated against BPJ on the basis of sex. The second case involves Lindsay Hecox, a transgender woman in Idaho. Hecox had been taking hormones and tried out for Boise State University's Women's Division I cross-country and track teams under Idaho's Fairness in Women's Sports Act, which similarly restricts women's sports teams to students assigned female at birth. The 9th Circuit had upheld an injunction blocking Idaho's law. Both cases came to the Supreme Court. Arguments were held on January 13, 2026. Justice Kavanaugh wrote the majority opinion, joined by Chief Justice Roberts and Justices Thomas, Alito, Gorsuch, and Barrett. The court reversed both circuit court decisions and remanded both cases for further proceedings consistent with its opinion. Now let me explain the headline number 6-3 and why it significantly understates the complexity of what the court actually did. The vote was 6-3 on the overall judgment reversing the lower courts. But on the specific legal question about Title IX, the federal civil rights statute, the vote was not 6-3. It was 9-0. All 9 justices agreed that Title IX does not require schools to allow transgender students to compete on teams matching their gender identity. Even Justice Sotomayor, who wrote the partial dissent joined by Justices Kagan and Jackson, explicitly agreed on the Title IX issue. She wrote that BPJ's Title IX claim fails because Title IX allows the sex distinction that West Virginia's law draws. This is significant. Title IX is the federal law most commonly cited in legal challenges to these state sports restrictions. It prohibits sex discrimination in federally funded education programs and has been the basis for expanding women's athletic opportunities since its passage in 1972. If any of the 9 justices had held that Title IX prohibits states from restricting female sports teams to biological females, it would have created an immediate legal obligation for federally funded schools nationwide. None of them held that. The legal foundation for state laws like West Virginia's and Idaho's is therefore considerably stronger than the 6-3 headline suggests. The Title IX door is closed on this question, at least as applied to sports teams. If you are finding this important, subscribe right now. This case closes a Supreme Court term that has been one of the most consequential in decades, and the legal implications of what was decided today and what was left open will be litigated for years. Subscribe so you stay ahead of every development. So where is the 6-3 split? It is on the Equal Protection Clause question. The 14th Amendment prohibits states from denying any person equal protection of the laws. The challengers argued that West Virginia's and Idaho's laws violate equal protection by discriminating against transgender athletes on the basis of their transgender status. Kavanaugh's majority opinion analyzed this under the Supreme Court's framework for sex-based classifications. Under that framework, A law that classifies people based on sex must be substantially related to an important governmental interest to be constitutional. Kavanaugh identified two important governmental interests that both states asserted: safety and competitive fairness. He wrote that allowing only biological females to play on women's and girls' teams can reduce the risk of physical injury and ensure fair competition. He found those interests were substantially served by the sex-based classification. The majority also relied on the court's 2025 decision in United States versus Skermeti, which upheld state restrictions on gender-affirming medical care for minors. Under Skermeti's analysis, these sports laws classify based on biological sex, not on gender identity or transgender status specifically. A law that classifies based on sex is analyzed under the sex-based classification standard, not a higher or lower standard. And under that standard, West Virginia and Idaho met their burden. One of the most practically significant aspects of Kavanaugh's majority opinion is the rejection of individualized exemptions. BPJ's lawyers argued specifically that she does not have the competitive physical advantages that typically concern states when they restrict trans athletes from female sports teams, because she received puberty blockers before undergoing male-typical puberty and then took estrogen-based hormone therapy. They argued she was an individual case that should be handled individually, not swept up by a categorical rule. Kavanaugh rejected this directly. Starting down the road of judicially managed individualized exemptions based on physical capabilities of individual athletes, he wrote, could fundamentally undermine women's and girls' sports, especially if the number of biological males who seek to play women's and girls' sports increases significantly over time. He said the questions involved in such individual assessments would be endless and bitter and yield few principled answers. The court would not require case-by-case physical capability evaluations for each transgender athlete who seeks an exemption. Justice Thomas wrote a separate concurrence. He argued that gender dysphoria, the medical condition that underlies a transgender identity, is a mutable mental state that is the object of psychiatric treatment and does not resemble the immutable characteristics like race, sex, or national origin on which the court has applied heightened scrutiny in equal protection cases. This concurrence signals where at least one justice would take the equal protection analysis for future transgender rights cases. Justice Gorsuch also wrote separately, focusing on the spending clause dimension of Title IX. Since Congress enacted Title IX under its power to spend money for the general welfare, the conditions it attaches to federal education funding must be clearly and unambiguously stated to bind recipients. Gorsuch found that nothing in Title IX clearly and unambiguously told schools they were prohibited from restricting female sports teams to biological females. This is a narrower technical argument about statutory interpretation rather than a broad constitutional holding, but it arrives at the same result. Now, let me explain the partial dissent, because its scope is important and because the dissenters actually agreed with more of the majority's conclusion than the 6-3 framing suggests. Sotomayor, joined by Kagan and Jackson, explicitly conceded the Title IX issue. She wrote that on that point, BPJ's claim fails because Title IX allows this sex distinction. What she disagreed with was the majority's decision to rule on the equal protection question at this stage. Her argument was procedural and factual. There are genuine unresolved questions of fact that the lower courts never fully addressed, specifically whether a transgender girl who has never undergone male puberty and who receives hormone therapy actually retains any physical competitive advantage over biological female athletes. Sotomayor argued the majority was wrong to decide the equal protection issue without waiting for those facts to be developed in the lower courts. The majority's decision to rule now, without that fact-finding, was, in Sotomayor's view, deciding the constitutional question prematurely. Jackson also wrote separately, joining Sotomayor's dissent and adding her own analysis. What the partial dissent does not do is challenge the result that transgender athletes lost in this case. They agreed that West Virginia's and Idaho's laws do not violate Title IX. They would have preserved the possibility of a successful equal protection claim after more fact-finding. But the majority foreclosed that possibility. Hey, 73% of people watching right now are not subscribed. Today, the Supreme Court issued its last major rulings of the term, including this one on transgender sports, the birthright citizenship case, and the campaign finance ruling. All three were 6-3. Subscribe right now so you understand the complete picture of what this term changed and what it left open. Let me now discuss something that legal observers are describing as an underappreciated aspect of Kavanaugh's opinion. Even though transgender athletes lost, Kavanaugh's equal protection analysis may actually provide them with more constitutional protection in other contexts than some people expected. By applying the intermediate scrutiny standard to these laws, which requires the state to show that a sex-based classification is substantially related to an important governmental interest, Kavanaugh has implicitly signaled that states cannot simply restrict transgender rights for any reason. They must identify a real important government interest and show their restriction is substantially related to it. In the sports context, safety and competitive fairness provided that justification. In other contexts, states that enact laws restricting transgender access to spaces or benefits will need to identify similarly concrete and substantial justifications. The Wall Street Journal's editorial board noted that Kavanaugh's opinion distinguishes this context from Bostock versus Clayton County, the 2020 case in which the court held that Title VII's ban on sex discrimination in employment extends to transgender employees. Kavanaugh said Bostock applied to employment and these cases apply to sports, and the two contexts are vastly different. That distinction could make it harder to apply Bostock's reasoning to other sex-segregated spaces such as locker rooms or bathrooms. Those questions are not decided by today's ruling, but the framework Kavanaugh established will shape how courts analyze them. Let me now address the national implications of this ruling clearly and specifically. 27 states currently have laws similar to West Virginia's Save Women's Sports Act and Idaho's Fairness in Women's Sports Act. Those 27 states include some of the most populous states in the South, Midwest, and Mountain West. Today's ruling provides constitutional clearance for all of them. Their laws restricting female sports teams to biological females are consistent with Title IX and with the Equal Protection Clause under the standard the majority established. School districts in those states can enforce their laws and, where their laws have been the subject of ongoing litigation, they can move to dismiss those challenges. States that do not have such laws are not required to adopt them by this ruling. The majority's language is that states may do this, not that they must. And public schools that receive federal funding and choose to allow transgender athletes to compete on teams matching gender identity are not prohibited from doing so by this ruling. The decision answers the constitutional floor question. It is constitutionally permissible to maintain biological sex-based teams. It does not set a ceiling that prevents more inclusive policies in states or schools that choose them. Let me also address what the ruling means for the specific students at the center of the cases. BPJ and Lindsay Hecox did not receive the relief they sought from the Supreme Court. Their cases are being sent back to the lower courts for further proceedings consistent with the majority opinion. What those further proceedings will involve is not fully specified in the decision. The ACLU, which represented BPJ, described the ruling as heartbreaking for their clients and for transgender girls who just want to have the same opportunities afforded to their peers. Attorney Joshua Block, senior counsel for the ACLU's LGBTQ and HIV Rights Project, said in a statement that it was a devastating decision for transgender girls who asked for nothing more than the same opportunities afforded to other girls. Kavanaugh himself acknowledged the human dimension directly in his opinion. He wrote that it is an unhappy occasion whenever a student who wants to play school sports cannot do so, and he expressed appreciation for every student who wants to participate. He closed his opinion urging that no student-athlete on either side of the issue, whether a biological female or transgender, deserves to be ostracized or vilified. That closing statement is remarkable coming at the end of an opinion that goes against the plaintiffs. It signals that Kavanaugh and the majority do not view this as a ruling against transgender people as such, but rather as a ruling about how federal law and the Constitution draw the boundaries of sex-based categories in athletic competition. Here is what you should understand about where the law now stands. On the specific question of whether states can require their public schools to maintain female sports teams based on biological sex, the Supreme Court has given a clear answer. Yes, they can. Title IX does not prevent it. The Equal Protection Clause does not prevent it. That question is settled. 27 states have already acted on a version of this policy. Their laws are now on solid constitutional footing. On the broader question of transgender rights in other sex-separated contexts, including locker rooms, bathrooms, and other facilities, the Supreme Court has not answered those questions today. The Bostock employment protection remains in place for transgender workers. The distinctions Kavanaugh drew between sports and employment are in the record and will be argued in future cases. On the question of whether individual transgender athletes who can show they have no physical competitive advantage might have a stronger equal protection claim, the majority's rejection of individualized exemptions in the sports context suggests that approach will face a very high bar, but that question technically remains open for the lower courts to address on remand. Subscribe right now because the lower court proceedings in these cases and the related litigation in other states will continue to develop. And as new cases work through the courts applying the framework Kavanaugh established today, I will cover every significant development. This is the last ruling of an extraordinary Supreme Court term that began last October and has produced landmark decisions on presidential power, immigration, campaign finance, digital privacy, religious freedom, gun rights, birthright citizenship, and now transgender sports. Each of those rulings shapes the legal landscape you live in. Understanding them accurately requires more than a headline. Stay with this channel for the full picture. This is educational content only, not legal advice. For any questions about how these decisions specifically affect a student, an athlete, or a school, consult a qualified attorney who knows both federal civil rights law and the laws of your specific state.